3 minutes, so keep talking. So we're going on this clock over here. That's the right one, not that one over there. Yeah, it's only 2 past. I'm expecting dozens more of you to come in through the doors. So. Okay, everyone, let's get started. Thank you. It's quite loud. Okay, what we're looking at for the next 2 weeks is this topic of mistake. That is, what happens when the parties to a contract have entered into that contract under a mistaken belief about some part of the bargain, perhaps about the subject matter, perhaps about what the terms of the contract say, perhaps about the quality of the thing that they were buying. What does the law have to say, or what does the law do to help, if anything, when there is that mistake? Perhaps one party is mistaken, perhaps both parties are mistaken, perhaps both parties are labouring under different mistakes. If you cast your mind back to the beginning of the year, if you cast your minds back to the beginning of the year, you'll remember some of those cases around formation, Smith and Hughes, Raffles and Wickelhouse. Those sorts of cases grapple with these situations. And you remember that the courts were there dealing with mistake in the context of whether or not a contract had actually been formed. And we'll see that that is actually how the courts used to deal with it in New Zealand, or at least part of the law used to deal with it. What we're going to do is start off by briefly looking at the statute, which deals with mistake, because that's always the best place to start. If you have a question about an area of a law that you don't know about, go to see if there's a statute that governs it and start there. But we'll see that the statute is not all-encompassing. And we'll also see that the statute is reacting to the state of law that existed at the time, which was felt to be deficient. So we're going to have to look at how the law is deficient to figure out what the statute was trying to solve. Okay, so that's what we're going to do today. Briefly look at the statute, and then we're going to step back and look at what the law was prior to the statute and what parts of the law prior to the statute remain. And there are two major areas that remain. That is the doctrine of non est factum, which is a common law doctrine, and then the equitable doctrine of rectification. We're going to do non est factum today, and then we'll look at rectification on Wednesday. And then next week, we will look at the substance of the statute and how it works in practice, the mistakes dealt with under there. Okay? Okay, so let's have a look firstly at the... wrong slides, beg your pardon. There we go, mistake. Okay, so we're going to start with the CCLA. It used to be called the Contractual Mistakes Act 1977, but in 2017, along with most of the other pieces of legislation dealing with contract law, the Mistakes Act was subsumed into the Contract and Commercial Law Act and is now in sections 21 through 30-something, 32 of the CCLA. So again, not many sections at all. Okay. So, for the purposes, we'll start off with section 21. What is the purpose of this legislation? Well, it's to mitigate the arbitrary effects of mistakes on contracts by giving courts appropriate powers to grant relief in the circumstances mentioned in section 24. Okay, so we can already see that there's some deficiency in the pre-existing law that this statute is expressly trying to deal with. The arbitrary effect of mistakes on contracts. But we'll just have a look in, they're in addition to and not in substitution for existing powers to grant relief in respect of matters other than mistakes. So the power to grant relief when there's a frustrated contract still exists. But most importantly, the remedies available for misrepresentation also continue, because there can be very easily a situation where one party has misrepresented an aspect of the contract to the other side, and that has led to the other party having a mistaken belief about the contract as well. So you can have both causes of action running side by side. But also straight off the bat, this section or this subpart is not to be exercised in a way that prejudices the general security of contractual relationships. And right at the start, we have within that section the tension that lies at the heart of the law relating to contractual mistakes. On the one hand, wanting to provide relief for parties who are genuinely mistaken and provide relief in a way that is not arbitrary. But on the other hand, not wanting to grant relief too readily, such that parties too readily escape their contractual obligations that they've signed up to in a way that prejudices, quote, the general security of contractual relationships. So just keep that in mind, that tension. Okay. Section 23 very briefly defines what a mistake is. Mistake means a mistake whether of law or of fact. mistake means a mistake is a interesting interpretation device, really helps. But it does give you some guidance that a mistake could also be a mistake as to the legal effect of a contractual document. A mistake in the interpretation of a document is a mistake of law. So if you mistakenly interpret what a guarantee means, for example, that could be a mistake. However, just to be aware, just because you mistakenly interpret the contract itself, that is not a mistake for the purposes of this subpart. We're going to look at interpretation next, but when there is a dispute as to what a contract means, if you lose that dispute, you can't then argue, well, I was mistaken and I should be granted relief under this subpart. A mistake in the interpretation of a contract is not a qualifying mistake for the subpart. Okay. So those are the kinds of mistakes covered. And we also see that under section 22, this subpart has effect in place of the rules of the common law and of equity. Okay, so we're going to look at the fact that the pre-existing law prior to the Act had differing results when there were mistakes, depending on whether the common law, you were asking for the common law to provide a remedy or equity to provide a remedy. Okay. And then subsection 3 says, even though this is to be a code, that is, it's meant to take effect of all the rules relating to mistake beforehand, there are some carve-outs. And the first two are the ones we're going to look at. The doctrine of non est factum, it is not my deed, and the law relating to the rectification of contracts. Furthermore, misrepresentation, undue influence, fraud, breach of fiduciary duty, frustrated contracts, illegal contracts are all exempt from this subpart. What that means is that this subpart does not have any impact on those areas of law. They are still able to be argued either in the alternative or concurrently with a mistake argument. So that's why we're going to look at in some detail these two areas of law, because despite the fact that the subpart was meant to be a code, it expressly keeps aspects of the pre-existing law relating to frustration, namely non est factum and rectification. Okay. Okay. What we're going to look at now, in the case of Taylor and Johnson, is the lens we're going to look at it through, is how the law prior to the CCLA in New Zealand dealt with mistakes, and what it was that this mistakes legislation was designed to remedy, or what the problem was with the pre-existing law. We will see that the law struggled with this question. And often the law, the common law, would say that actually when the parties, one or both parties, are mistaken, the contract, there is no contract, there's no meeting of the minds. And therefore no contract was entered into. Now, just a side note, under section 23.4, this is no longer a problem. If you have a qualifying mistake under section 24, you cannot argue that there was no contract entered into. You are to assume that there was a contract entered into, even if one party was mistaken, or both parties were mistaken. So the common law's approach was to say Mistake is really a question of formation and whether there has been a meeting of the minds, and therefore whether a contract has been entered into at all. That was the common law's approach. Equity had a different approach. Equity came at it from a different lens. Now, you've not done equity as a subject. How much, if anything, have you learned about the difference between common law and equity, either historically, substantively, at all? In part one or this year, do you have any idea what I'm talking about, or is this completely Greek? Okay. So, let's give you a brief primer on common law versus equity. It's often said that the English legal system which we inherited is one that no one in their right mind would sit down and think up from scratch. It is instead something that grew up over hundreds of years through a historical development in a sometimes illogical, sometimes even contradictory way. It's very organic. That grew up, as I say, over centuries through a number of decisions and historical developments, rather than formulated in one go, like, for example, a civil code in Europe. One of those peculiar aspects of the English legal system is that up until the middle or the later part of the 19th century, you had two legal systems running two separate court systems with two sets of judges and two sets of lawyers. You had the court of equity or chancery and the court of common law. I'm actually simplifying things, because in common law there were all sorts of sub-courts such as admiralty, family, probate, King's Bench, etc., etc. But for our purposes, we're just going to keep it simple. You had chancery or equity courts and you had common law courts. And they grew out of different traditions and different ways of seeing the world. Equity grew out of the Court of Chancery, which was the institution that was set up to help the Chancellor, the Lord Chancellor, who was the keeper of the king or queen's, but mostly king's, conscience. That is, there were mostly kings rather than queens, but there were some queens in the Middle Ages in the UK. In England. The point was that the king was the fount of all justice. So that meant if there was a problem with a common law decision, or you went and you found that the common law was not providing you justice in your case, you always had the opportunity and the option to go to the king and ask for justice in my case. Okay, your courts, king, are not providing me with justice. Please grant justice out of your inherent powers. This very quickly became unwieldy. The king said, go and talk to my chancellor, he will dispense it on my behalf. Very quickly got unwieldy for the chancellor. He set up courts of chancery where there were judges who would dispense justice in particular cases for these particular parties. Unlike the common law, chancery, the Court of Chancery was not about rules. It was not about any sort of rule utilitarianism or setting out certainty. It was about providing justice for individuals in individual cases. On top of that, it was staffed by and influenced heavily by the church, because they were the people who could read and write generally, but also because it was drawing upon church courts that had hundreds of years of experience, both in England and on the continent. And so that meant that Chancery from its beginning was heavily influenced by concerns about the conscience of the parties and preventing one or either party from relying on their legal rights when to do so would be unconscionable. Indeed, the courts would go further, the Chancery courts, and would say, we cannot allow you to exercise your legal rights because that would actually put your soul in danger. Okay? That would be unconscionable. We are protecting you from yourself. But you can see very quickly that is a very different understanding of what the courts are about or what they're trying to do to the common law courts. What does that mean when it comes to contract law? Well, generally, it means that while in the common law courts, the writing was everything. That is, the contractual document was the beginning and the end of the matter. Do you have a contractual document that gives you this right? Yes. I will enforce it because it's in writing and it has been signed and it has been witnessed. Okay, there's no issue. But then in Chancery courts, that very same dispute, the Court of Chancery would look at things like, was one of the parties mistaken? Were one of the parties mistaken? And did the other party know of that mistake? Would it be unconscionable for one party to enforce this contractual document because they knew that the other party was mistaken? They knew that they would be they know that they would be enforcing an agreement that the other party never intended. And they know they never intended it. It would be unconscionable to do so. So what does that mean when it comes to mistakes? Well, generally, in common law, the courts would say, has there been a meeting of the minds? And we will assess that objectively. Objectively, is there an agreement between the parties? And how do we figure that out? Well, we look at the written document. Did you sign this agreement? Yes, okay, we will hold you to that. It provides certainty. It allows third parties to know where they stand if they're wanting to rely on this contract. And it also encourages parties to protect themselves by reading carefully, by having legal advice if necessary. The Court of Chancery, on the other hand, would say, you cannot enforce this agreement if you knew that the other party was entering into it under a mistake. That mistake was fundamental to the contract, and that were you to enforce your contractual terms, it would be unconscionable for you to do so. And if that's the case, despite the common law saying that this contract should be enforced according to its writing, equity would come in and say, no, we are not allowing you to enforce it. We are going to grant the other party rescission of the contract, which would mean that it was void ab initio from the start. Okay, so you've got those two different courts coming to contract law very, very differently. From 1870 in England, these courts have been merged, and now judges and lawyers, barristers in the UK have the competency to argue both law and equity. In New Zealand, there were never separate courts because we didn't have the population to support that. From the very start, New Zealand judges have had the competency and the power to dispense both law and equity. Right. So, that is why nowadays you can have judges dispensing, as I say, talking about the common law, say, for example, the doctrine of non est factum, and also equitable doctrines such as rectification. Okay. So, the common law's approach to mistake would be to look at formation. The equitable approach would be to look and say, is there a fundamental mistake that one party has made, irrespective of whether they signed it, that the other party knew about, such that it will be unconscionable to enforce? If so, we will grant the innocent party rescission of the contract, which renders it void ab initio from the start. Very clear to point out now that rescission is no longer part of the law. This whole approach has been overtaken by the Contract and Commercial Law Act. But it's useful to know why it was overtaken and what the concerns was. So, obviously, relying solely on the written document may provide injustice in certain circumstances. And that's where equity would intervene, which would grant rescission and make the contract void ab initio, that is void from the start. So it's not about whether or not a contract was formed. The equity would assume that there is a contract at common law, but would step in and say, even though there is a contract, it would be unconscionable for you to enforce it when you knew that that was not what the other party intended. And in that case, the other party can rescind the contract, be granted rescission. Okay? So again, equity is looking to the conscience of the parties, whereby Party A would ask the court to rescind a contract entered into due to their mistake, if doing so was necessary for the preservation of the conscience of B. It's all about the fact that the defendant, or the party seeking to rely on this contract, it would be unconscionable for them to do so. However, you couldn't get rescission for any particular mistake. You had to show that the mistake went to the root of the contract or a fundamental aspect of the contract. So it would not be enough to say this particular item that I'm buying is different in quality to what I thought it was going to be. A mistake as to quality would not be able to get you rescission. Caveat emptor would apply. Buyer beware. So again, it requires that B knew of this mistake when entering into the contract. So if B entered into the contract knowing that A was mistaken as to a fundamental part of it, then it would be unconscionable for B to enforce the agreement, and the courts would decline to do so. The trouble with this approach is essentially the remedy. It is a drastic one. The contract is void ab initio. It never existed. Which you can imagine brings forth all sorts of practical problems. First of all, how do you unwind it if it's been partly performed prior to Party A realising that there was a mistake as to a fundamental term? What happens to third parties who have been perhaps transferred property that is the subject of the contract? What happens if third parties have lent money on the strength of the contract? What happens to their rights if those rights were reliant upon the contract existing and equities coming in and saying, no, this contract never existed from the start? This drastic remedy, or this all or nothing remedy, there were two options: either it never existed or it's just enforced in full, in many ways limited the operation of rescission, because the courts, of course, were aware that if they grant rescission, these drastic consequences will arise. And in some cases, the courts would just say, this is equity, we have a discretion here, we are not going to apply, we're not going to grant rescission because it would detrimentally affect third parties. Which meant that often deserving plaintiffs would not be granted rescission because of that drastic remedy. Okay, but as I said, it relies or assumes that there is a contract. The approach that the common law took was all about formation and whether in fact there was a contract. And effectively there were two competing approaches to contract formation that kind of come through in those cases you looked at the start of the year that were really in competition, particularly in the 19th century, but seem to have, the competition has died away, I'd say, in the last 100 years or so. And those competing approaches are firstly the objective approach, illustrated by cases such as Upton on Severn, which says that the written contract is all. It's not about what you subjectively intended, it's about what your intention was as objectively manifest in the written document. Why? Because we need certainty. The written document provides us with that certainty. We can't look inside your head, but we can read the contract that you agreed to. And so we'll enforce that. And effectively, the common law would say, under the objective approach, one party should not be able to escape their written bargain just because they individually made a mistake. If that mistake was known to the other party, then perhaps equity would step in. And this is to be contrasted, with a more subjective approach, illustrated by cases such as Hannah Blumenthal and Smith and Hughes. Remember, Smith and Hughes is the racehorse case with the old versus the new oats. It's all coming back to you, I'm sure. Which says that, relies very heavily upon the will theory of contract, that the whole point of contract law is to enforce bargains that parties freely enter into. Well, therefore, their subjective will should be respected and enforced. And therefore, you need to show subjectively that there was agreement, there was consensus ad idem, before you can say that there was a contract actually formed. But as we're going to see in Taylor and Johnson, in practice, the same result would probably be reached under either approach. Because remember, in Smith and Hughes, the court says it's all about or at least some of the judges say, it's all about the subjective intention of the parties. So therefore, if you did not actually agree with the other party, there is no contract. But on top of that, you are stopped or prevented from arguing that you didn't agree to this written contract when your actions by signing the contract would say to a reasonable person that that's what you intend, which actually gets you to the same approach as, same result as the objective approach. Okay, let's bring this all together in the case of Taylor and Johnson, which is an Australian High Court case, so the highest court in Australia, which shows you both the objective approach to contract formation and then the intervention of equity through rescission. And the case is very simple. It's the sale and purchase of land, where the purchasers thought that the 10 acres were being sold for $15,000 flat. And the vendors thought that this land was being sold for $15,000 per acre. So overall, the difference in purchase price was The vendors thought it was 150 grand. The purchasers thought it was 15 grand. And both sides, it was found, thought that the other side was mistaken. So effectively, the court says both sides were being a little bit tricky. They both thought that the contract reflected their understanding of the price, and they both thought the other party may not have picked it up. Having said that, the trial judge had found something different. This case is great for illustrating the legal principles, but in many respects it's problematic because of how the Court of Appeal and then the majority of the High Court of Australia overturned the trial judge's finding as to fact. And generally, appellate courts should not overturn findings of fact made by trial judges. Why? Because trial judges have the benefit of seeing the witnesses themselves. And in this case, the trial judge found that both witnesses seemed to be telling the truth. And the Court of Appeal, who didn't see the trial or the witnesses, effectively said that the purchaser was lying. Was lying all the way through the transaction and was lying all the way through the case, which is a pretty interesting thing for the Court of Appeal to do. And that's why you have the minority judgment of the High Court of Australia, Justice Dawson, effectively dissenting on this ground. He's saying we should not be overturning a trial judge's finding of fact. What did the trial judge held? The trial judge held that actually the purchaser, who thought that the price was $15,000, had not realised or did not know that the vendor was mistaken. Okay. But anyway, that's just a wrinkle. Just leave that aside. Let's assume they both thought the other party was mistaken. Well, only one of them can be correct according to the words of the contract. And it turns out that the purchaser was correct. The price was $15,000 all up. And so they signed the agreement, and then they went to transfer the property, and the vendor refused to transfer title. And so the purchaser sought specific performance, which is what specific performance? Yeah, thank you. Yeah, it's not claim for damages, it is a claim in equity for the performance of the contract. And this is the general remedy for land transactions. And so, effectively, the purchaser was saying, hey, we've got a contract, transfer the title in accordance with the contract. And the vendor sought rectification, which we'll just park to one side, but effectively an equitable doctrine that we'll look at on Wednesday. And secondly, the setting aside of the contract in equity according to rescission. So as I've already said, the trial judge held that the purchaser was not mistaken, i.e. they thought it was for $15,000 and it was for $15,000. And furthermore, they didn't realise that the vendor thought something different. And therefore, the trial judge says, we have a contract, I'm going to enforce that contract according to its terms, and there is no reason for me in equity to set that contract aside. It would not be unconscionable to enforce this agreement because the vendor may have been mistaken, but the purchaser didn't know that. So it's not unconscionable for the purchaser to enforce that bargain. It would only be if they knew that the other party was mistaken, would it be unconscionable. As I said, this was overturned as a matter of fact by the Court of Appeal in the majority of the High Court of Australia, where they held that both sides thought the other party was mistaken as to the price and tried to keep the real price from each other. I think that is highly... Anyway, I think the dissenting judge has a very good argument. But the majority held that the purchaser deliberately set out to ensure that the vendor didn't realize her mistake. Effectively, he didn't bring it to her attention, and he tried to make sure that she didn't closely read the contract so that she realized that the price was 15 grand and not 15 per acre. Okay, so we've got both parties thinking the price is something different. The contract, as written, reflects only one of their beliefs. How would the common law approach this? Well, the court says the common law would figure out whether in fact there is a bargain here at all. Has there been valid formation? Is there a meeting of the minds? And the first approach would be, according to the subjective approach, Smith and Hughes, if one party has a fundamental mistake as to a term or the content of the contract, and the other party knows of that mistake, then you'd say there's no meeting of the minds and no contract. The other approach, or the other theory, the objective one, would be to say, what are the objective outward manifestations of intention? Don't worry about what they're actually thinking. Look at what they did and how a reasonable person apprehending what they did would have thought they were doing. What did they write? What did they say? What did they do? What would a reasonable person looking at what they wrote and what they said and what they did, what would a reasonable person think that they intended? And obviously, in this approach, the subjective approach would be to say there's no contract in this case. The objective approach would be to say there is a contract in accordance with the contract that was written and signed by both parties. However, the court says, actually, no matter what approach we take, it's probably going to be the same result, because even if you are mistaken subjectively about a fundamental term of the contract, you will be prevented or stopped from arguing that if your objective manifestations or your conduct suggests something differently. So if I think that the price is $15,000 per acre, we don't have a subjective meeting of the minds. But if I then go and sign a document that says $15,000 full stop, how would a reasonable person interpret my actions? They would interpret my actions as thinking, I intend to sell for $15,000 flat. And therefore, because of those actions, which a reasonable person would interpret in that way, I am prevented by my actions from arguing my subjective intention. So actually, under the subjective approach as well, there would be a contract under common law. The court says there are some differences in the outcome, which we won't go into, but importantly they say, look, in the common law now, the objective approach is the most popular at the moment and is the one we're going to apply. Objectively, therefore, there is a contract, there was valid formation because both parties signed the contract and it's very clear what the price was under that contract. Okay, so at common law we've got a contract. Can we, though, come in with our equitable principles and allow the vendor to escape her mistake? Essentially, would it be unconscionable for the purchaser to enforce this agreement? And the court says, well, did the purchaser deliberately set out to ensure that the vendor was not aware of the mistake? And the court said yes. Here the vendor had made a fundamental mistake as to the price. The purchaser knew she'd made a mistake, set out to make sure that that mistake was not discovered by the vendor prior to signing, and therefore it would now be unconscionable for the purchaser to enforce this agreement, and we are not going to grant specific performance. And so therefore the contract is void ab initio. There was no agreement or none that can be enforced, and the vendor is free to go and sell that property again at a higher price, and the purchaser cannot buy it for a bargain. So what we see in the majority approach is figuring out, okay, there's a mistake here. Does that affect formation under the common law? There are two approaches, objective and subjective. They probably reach the same result no matter which approach we take. There is a contract. The common law is going to look to the writing and say there is a contract. That is a fundamental to the common law. Certainty is key. And then you had equity coming in and saying, even though there is a formed contract, we, under equity, are going to prevent the purchaser enforcing this agreement because it would be unconscionable for the purchaser to do so. Why? Because they knew the other party was mistaken about the price, and therefore it would be unconscionable for them to now enforce it against that party. Again, though, the only remedies here under common law or rescission in equity, the only remedies are binary. Either the contract as it stands is enforced in full, irrespective of any mistakes any party has made, or the contract never existed or is void ab initio under rescission, which means no part of the contract can be enforced. It's all or nothing. In this case, that's fine because no part of the contract was performed prior to this case. The whole case arose because one party wouldn't perform. Nor are there third parties that we know of affected by this contract. So unwinding it or saying it never existed or making it void ab initio doesn't affect other parties, isn't a problem, and so the court is able to do that. This is how a mistake case would have been argued prior to the Contract and Commercial Law Act 2017, the Contractual Mistakes Act 1977, prior to the mistakes legislation in New Zealand. You can see that it's not entirely straightforward. The law was not straightforward. Even the common law was not clear which approach, objective approach probably would prevail, but there was a competing approach, the subjective approach, which then relied on estoppel, then you have rescission coming in. It's not clear at all how this would be applied. And then you have the problem, as I say, of the all or nothing remedy or relief to be granted. And really this is again this tension between, on the one hand, enforcing objectively entered into bargains, which provides certainty and encourages people to not make mistakes, and on the other hand, not wishing to enforce agreements against a party that did not intend to enter into those obligations. When there's no meeting of the minds, what do we do? And that's the tension that both the common law and equity were trying to grapple with, and that you see come out in this case of Taylor and Johnson. And that's what the law was prior to the enactment of the CCLA. Are there any questions at all about this? Yeah.
Could you explain a bit more about the subjective and objective approach? Because I thought Smith and Hughes was all about objective manifest intent.
Sorry, objective and
Manifest intent, not what you subjectively believe.
right. Well, so that is again the tension between the two is firstly, what did Smith and Hughes actually mean? That's one of the problems. That there are different judges who say different things that suggest a more objective or subjective approach. What the difference between the two are is whether you enforce the parties' subjective intentions, whether you need to have an actual meeting of their subjective minds, which the will theory would suggest you do, for a contract to be entered into. And if you are enforcing that, how does that interact with the outward manifestations of their intent? And the difficulty, and we'll see this come up again in interpretation, the difficulty of thinking about someone's intention separate from any outward manifestations of it. How do we know what anyone's intention is? Well, we look at what they say, do, and write. And so the objective approach would say, no, the bargain is the writing. What is it, or the objective interactions between the parties, usually writing. What is it that the parties intended as viewed objectively? So what does the writing objectively mean? Well, that's the objective approach. You are held to that bargain. That's your intention. Subjective approach is, what did you actually intend? But you can't argue you actually intended something different from what you did, because your outward manifestations, as viewed by a reasonable person, prevent or stop you from arguing something different. So I can't argue that the price that I intended was $15,000 per acre when my actions, by signing a contract, what does the signing mean? I agree to these words. Signing a contract which says the price is $15,000 flat. So we actually get to the same result. But you are pointing at something, is that this is not clear. You have different strands coming in. The objective approach is much more long-standing in the common law. The subjective approach is a way to try and marry a will theory of contract with this concern about certainty and objective intention. But you get to the same result, effectively. But again, this was the trouble with the law in trying to grapple with what we do when one party is fundamentally mistaken. In the common law, it was all about whether there was a formation, a meeting of the minds. Equity, would it be unconscionable for you to enforce this bargain when you knew the other party was mistaken? And if so, we'll get rescission. Questions? Other questions? You can see why, hopefully, why the legislature came in to pass a law to do away with these approaches, because it was not thought to be working. Okay. But do keep in mind that tension between the certainty of contractual obligations, being held to what you actually said, and the concern of not holding someone to something they really did not intend to. If the contract law is all about holding people to their bargains and what they intended, what do you do when someone really did not intend that? Okay, let's have a break now, and we'll come back and we'll do non-est factum, which has survived and is still part of the law. Okay. So that's all background. That's all background for how the law grappled with the mistake and how the law in New Zealand would have grappled with mistake prior to the passing of the mistakes legislation. There are a couple of other doctrines or areas of law which would have applied prior to the mistakes legislation being passed, and thanks to section 22 subsection 3 are still preserved after the passing of this legislation. Those are non est factum and rectification. We'll do rectification on Wednesday, we'll do non est factum now. Non est factum means it is not my deed. What's really interesting about non est factum is, remember I said the common law is only concerned really with the writing, with the contract as what you wrote and what you agreed to and signed will be enforced, and it's important to have certainty. There was a narrow exception to that, which goes 180 degrees against what I just said about the common law. The common law from about the 16th century allowed an exception where you could show that even though there was a written contract, or in fact as it started off, a deed, if there's a deed that was, obviously it was written, it had to be signed by you, you could still escape the consequences of the deed and say in fact there was no agreement if you could prove non est factum. And as I say, it's still preserved under the current legislation. Essentially, you are saying that you did not consent to this contract or to this deed, which otherwise your writing and your signature appear to evidence. And effectively, this is to protect people who, through no fault of their own, have had a contractual document erroneously described to them. And that doesn't have to be fraudulent, although it could be. It could be that someone is just mistaken. And originally it was very narrow. And it was limited to those who, from illiteracy or blindness, were unable to figure out what the document says. Had that document erroneously described to them, they signed it, and then they found out that the document they signed was not what they intended. So the starting case for this is one from back in the 1580s. It's known as Thorogood's case. And it's quite funny. It's all about the effect of a deed which Thorogood signed. And it was drawn up, and the Thorogood was a layman. He wasn't lettered, that means he didn't read or write very well. And he started to read it. After that, one Thomas Ward had begun to read it to the plaintiff. And before he had read a line of the writing, one John Ward took the writing out of his hands, saying to the plaintiff, "Good man Thorogood, you are a man unlearned, and I will declare it unto you and make you understand it better than you can by hearing of it read." So effectively, Thorogood couldn't read it. He got one of his friends to start reading it, and the friend's brother, I assume, was like, whoa, my brother's useless as well. I'll read it to you because you can't read. You are unlearned, but you're a good man, so that's probably more important. Right. The problem is that despite his what he said, the man who read it to him incorrectly described the document. Now, we shouldn't be too harsh. Remember, back in this time, a lot of documents would have been drawn up in Latin. Some of them would have been drawn up in legal French, sometimes in English, sometimes in a mixture of all three. And also, even if in English, they would have been dealing with jargon, which has specific legal effects, so that even if it was read to you, you may not understand the import of that jargon. And that, I think, is what happened here, is that the plaintiff Thorogood was owed some money according to effectively a lease. He decided to forgive the money owed, and he did so, or he wanted to do so, via a deed. And the deed was read to him, and it was said, "This is but a release of the arrearages," that is, a release of the money that was owed to you under this lease. And Thorogood said, "If it be no otherwise, I am content." So I am content with signing something if it releases them from the rent that was owed. Unfortunately, it wasn't a release of the rent solely. It also released the defendant of all obligations in the future to the plaintiff. And so when the plaintiff found out about this, he sought to have the deed set aside as not binding because he said this was not his deed, non est factum. And the court allowed his plea and said it was this deed did not bind him. Why? Because when an unlettered man is deceived as to what is in a deed by someone else reading to him, and the plaintiff can't read himself, then you can't say that what he signed up to was what he intended. And if you think about it, back in the 16th century, there is some debate about how many people were illiterate, but certainly a high standard of literacy to understand and read and comprehend legal documents was not high. So this was a way to protect people who the only way they could enter into legal arrangements would be, contractual arrangements at least, would be to have to rely on someone else telling them what they were signing. And so to protect those people when what they were told was not in accordance with what they thought they were signing. And so that's where the non est factum began. It was limited to those who were illiterate and those who were blind, and when they had had the effect of the document or the agreement misinterpreted or told to them incorrectly. In the 19th century, the narrow doctrine expanded. It expanded in two ways. Firstly, it expanded from solely applying to deeds to also include written simple contracts. Bargains, what we mainly deal with in this course. Furthermore, the court abandoned the requirement that the reason you couldn't read the document is because you can't read full stop. So even if you are literate, you may still be able to claim non est factum. And instead it came down to whether or not you consented to the agreement that you signed. And whether the fact that you didn't agree to what you signed was through no fault of your own. However, despite the expanding of the doctrine in these ways, the courts were and are still very much concerned about making sure that this doctrine does not undermine the rights of third parties who have relied upon the written agreement. So the most obvious example is I enter into a contract to buy a property or buy business or something, and on the strength of that agreement, a bank lends me money. If that agreement is unwound, that affects the security that the bank has in order to lend the money, and so the courts are aware of the effect that unwinding the contract would have on that third-party bank. And so when a third party would be adversely affected by a successful plea of non-est factum, in all likelihood, the plea will not succeed. If it comes down to determining between a third party who relied on someone's signature and the innocent signatory who was deceived, generally the courts will place any loss on the signatory. What that means is non-est factum won't be able to succeed if a third party would lose out. And we'll see how that plays in a couple of New Zealand cases in a minute. Okay, what do you have to show to plead non-est factum? You've got the problem of third parties I've just mentioned. But firstly, you have to prove, as a matter of evidence on the balance of probabilities, that what you signed was not what you intended the document to do. And the document, not only must you be mistaken as to the document, but the effect of that mistake must be very high. That is, the document is very different or fundamentally different from what you actually intended. There was a debate as to whether or not non-est factum only applied to contracts that were different in kind, not effect. So that is, I signed a lease agreement where I actually meant to sign a sale and purchase agreement. That's obviously different in kind. The court said, no, it's not about whether it's different in kind. You can have lease agreements that you signed intending it to be a lease agreement, and the effects are very different because I signed it thinking it was $1 a year and it turns out to be $1 million a year. Obviously, that's very different. So it doesn't matter what the type of document is. You just have to show that what you signed was very different from what you intended. It's a high threshold. And you have to show that the reason the signatory signed something which it wasn't what they intended was through no fault of their own. That the signatory wasn't negligent in some way. That they acted with due care in signing this document despite it not reflecting what they intended. Which suggests that the signatory must be misled in some way by someone who it's reasonable to trust. And if you can show that, the result is that the contract is void, never existed. Okay, we're going to turn to Lanziel group now, but are there any questions before we get into this? It is quite an interesting exception from the common law's insistence that the writing is everything. And it's interesting that once mass illiteracy went away in the late 19th, early 20th century, that the common law still kept it. There could have easily been an argument to say we don't need this doctrine anymore because the reasons for it have gone away. But it was kept. Everyone happy so far? Any questions? Okay. So, Lanziel group. What is important from this case is when you're trying to plead non-est factum or trying to figure out if the courts would allow a plea of non-est factum to succeed, you need to test the effect of a successful pleading and a setting aside of the contract versus continuing on with the written agreement. What we see in this case is the New Zealand High Court adopting a similar approach used by the House of Lords in a very famous case called Sanders and Anglia. And Sanders and Anglia re-emphasise the fact that it's about ensuring that the signer of the document was not negligent in some way. And when I use the word negligent, I mean that in the layman's term, not in the tortious sense. So it's not about a duty of care or a breach of that duty. It's merely whether they were careless, or that it's not their fault that they don't understand what they were signing. But also Sanders and Anglia says that it doesn't matter what kind of document it is, it's just whether it's very different. And that is a high threshold. The question here in this case was whether a contractor at a car bodyworks shop was bound to a contract agreement or an employment agreement. It's not quite clear what. The court said it doesn't matter how we describe it. Whether they were bound to this agreement which had a restraint of trade clause in it, which on the face of it prevented the contractor from going and setting up in competition with his employer. And the contractor could have argued that the clause was illegal and gone through the cases that you looked at in the first semester. This semester with Josh. But the first argument they ran was this clause doesn't apply because I never consented to it non est facto. This is not my deed. And the employer's argument was, yes, you did. Here's the contract with the restraint of trade clause in it, and you signed it. The facts were this. The employer had been talking to the contractor prior to employment and said, yeah, we'd love you to work for us. Here's a contract, take it away and read. Fortunately, the employer didn't have an up-to-date version of the contract, so stapled together some random pages which pretty much gave a mixture of the old and the new and said, take it away and read. Importantly, that earlier version did not include a restraint of trade clause. He then came into the office and said, yeah, I've read it. It seems like there's some pages missing, or it seems a bit weird. These pages don't line up typographically. And the employer said, don't worry about that. That's just the earlier version. Here's the updated version. It's materially the same. And that new version did have a restraint of trade clause in it. And that's what the employee or the contractor signed. He didn't read the new contract. He took it on the employer's word that it was materially the same and signed it thinking it was, what he'd taken home and read. Now, on the face of it, this contractor arguably should have read that new version. That was the version he was signing. He should have at least flicked through it and figured out that it was different or not. There's no argument that he was illiterate or blind. He could physically read that document. And yet, despite that, the High Court said that non est factum was satisfied. Firstly, was the document that he signed radically or very or fundamentally different from what he thought he was signing. So what he thought he was signing was an agreement without a restraint of trade clause, and what he actually signed was an agreement with a restraint of trade clause. They were both employment agreements, so prior to Sanders and Anglia, he probably would have failed because the document was not different in kind. It was still the same thing. But the terms of the document, the court said, were radically different. A restraint of trade clause is, or having a restraint of trade clause is a very different employment agreement from not having a restraint of trade clause. You are effectively selling your right to work after the employment agreement has come to an end. That, the court said, is radically different from not selling your right to work after the employment agreement has come to an end. Underlying that is, of course, I think the court's reluctance or hostility, I would argue, to restraint of trade clauses generally, which is reflected in the Illegal Contracts Act. Okay, it's radically different. That's the first step. The second step is, was he careless or was it his fault that he signed something that was radically different from what he thought? Did the fact that he didn't read that new document preclude him from arguing non est factum? And the court said no. And I think there were two reasons for this. Firstly, whether or not this contract is void according to non est factum only impacts the contractual rights of the employer and the contractor himself. There are no third-party interests that would be affected by a holding that this contract, that there's a successful finding of non est factum. So the courts aren't concerned about third parties' rights. They are only concerned about the rights of this employee/contractor and this employer. So between those two, who should bear the loss? The court says it's the employer. The reason the plaintiff didn't read that new document was that he was misled by the employer as to its effect. The employer told him that it was materially the same as the document he had taken home. And in those circumstances, the court said it wasn't unreasonable for the employee to rely on the words of the employer. So he's not blind, he's not illiterate, he had a chance to read it and chose not to, and yet still non est factum was successful. Why? Because no third parties were involved. The document was very different to what he thought it was. And the reason he signed something, or a large part of the reason he signed something without reading it, was because the employer misled him. In those circumstances, the court said, yep, non est factum, will enforce it. So the contract was void, and therefore the restraint of trade clause did not prevent him from setting up in competition because there was no restraint of trade clause because the contract's void. Does that make sense? Any questions at all? Cool? Okay. Well, if that's the case, let's go to the last case I want to look at, which is Bradley West Solicitors, which is Justice Tipping before he got to the Supreme Court. And it's an excellent summary by His Honour of the doctrine of non est factum in New Zealand, in which he draws upon cases, particularly Sanders and Anglia. Okay. The question there was whether borrowers who had borrowed money were able to void the loan agreement, which not only increased the amount of money lent to their company, but included a personal guarantee. So a personal guarantee was, my company is going to borrow all this money, and if the company doesn't pay it back, then I will personally guarantee that money. Often it's a requirement for companies, particularly smaller companies, when they are borrowing money, that their directors or their shareholders or someone provides a personal guarantee, so that if the company fails or goes under, there is someone else that the lender of money has recourse to. Okay? So, they were advised by their lawyer about this loan agreement. And it was held on the facts that the lawyer told them accurately that this loan agreement included a personal guarantee. But what the lawyer failed to do, the court held, was really tell them what that means. It's one thing to say there's a personal guarantee. There's another thing to make them aware of the impact and the practical implications of that personal guarantee. So they signed this loan agreement. Things did not go well, and the lender is seeking to enforce this personal guarantee against them. And they argued, the borrowers argued non est factum. And they were held not to be able to plead it. And I'd like to draw your attention to these 6 principles which Justice Tipping draws forth. I'll try and zoom it in a bit. Oh, whoa. Oh man, what's... Okay, he's saying this is not a test, but these are some of the points that have arisen from the authorities. Okay, point 1. The person raising non est factum must have signed the document believing it to have a particular character or effect. Okay, so you've got to think that the document means something. That's probably fairly easy. Number 2, the document must in reality have a radically different character or effect, thus creating a wholly different result from that which was understood by the proponent. This is showing how different the contract in reality needs to be from that which was actually signed. The proponent's mistaken belief must have resulted from an erroneous explanation or description of the document given to him by someone else. So effectively, Justice Tipping is saying the only way you can plead this is if, for some reason, someone misled you. You then must be able to show, if you're pleading non est factum, that notwithstanding the fact that you were mistaken, you entered into this agreement with all reasonable care in the circumstances. And point 5 is interesting and highly relevant for this judgment. If your mistaken belief arises because you acted in reliance upon a trusted advisor such as a solicitor, and he did not take steps to read and understand the document prior to signing it, you cannot plead non est factum. Why? Why, if you get a solicitor to explain a document to you, are you not able to plead non est factum when the solicitor does it badly? That seems to be, you're taking all reasonable care, right? That seems to be a very sensible thing to do. I get the solicitor to tell me what is in it, and I rely on the solicitor. They tell me wrong, I can plead non est factum. Yeah, why not?
I think it kind of balances up the interests of the party. Because then it would be fair, like if you just let you hook because your lawyer did a bad job.
Excellent. So the requirement or the getting of legal advice is often something that's required under an agreement, or will be something that the other party knows about, or will be something that will be stipulated in the contract, I have sought legal advice, or will be something that statutes require. And the other party will rely on the fact that you've got this independent legal advice, and therefore that you know what you're getting into. And so if it turns out that you don't know what you're getting into because your independent legal advice is incorrect, then why should the other party, who's wholly innocent, who has not misled you in any way, has relied on your signature, why should they not be able to rely on your signature just because your lawyer got it wrong? Yeah, great. So another point over here, was that the same one? Another hand over there? Same point, or?
Yeah, I think it's a case of misstatement of the lawyer. Like,
Yes.
you should sue the lawyer instead of like the other party.
Fantastic. Yes, absolutely. You have a clear case or claim against the lawyer. Maybe in some sort of tortious, negligent misstatement, but more obviously in contract. You have a contract of service with your lawyer. There would be expressed or implied in there a requirement that the lawyer provides good, reasonable advice. Therefore, if the lawyer's at fault, sue the lawyer. Why should the lawyer get off the hook and the poor other party who's relied on your signature to have to take the losses? Make sense? And that's exactly what the court held in this case. At most here, they were misled by their own lawyer. And there are good reasons that we've just gone through for not voiding the agreement in those circumstances. And the court later on in 121 says, one may be perfectly entitled to rely on a trusted advisor, and that in a sense is not a failure to take reasonable care, but for present purposes it is treated as being such. Put bluntly, the law, as a matter of policy, does not allow the plea of non est factum when the erroneous explanation or description is given by the signatory's own solicitor. A fortiori, that is, even more strongly, when that solicitor witnesses the signature, thereby impliedly affirming that the signatory knew and understand what he or she was signing. So in this case, not only did the solicitor explain what was going on, the solicitor witnessed the signature, which says to the other party that there was a solicitor present who gave advice. And the other party should be able to rely on that to say that this is what you actually intended to agree to. The remedy, if any, is against the advisor and not by having the document declared void. Okay, go sue your lawyer, don't try and get out of this agreement. So you force the lenders to go after their own lawyers. Furthermore, actually on the facts, the court said they didn't really. Let's go back to that first point. You have to, raising the plea, the plaintiff must have entered the document believing it to have a particular character or effect. On the facts, it seemed clear that the parties signing the agreement, signing the loan, which included this personal guarantee, had no particular belief about the effect of that document. They were merely signing whatever they needed to sign in order to get this loan through. In short, they were signing whatever their lawyer put in front of them. So more fundamentally, the court said they didn't actually think this document contained anything, or they didn't care what it contained. There was no mistaken belief about what this document said because they had no belief about it at all. It was not radically different from what they thought they were signing, because to be radically different, you have to have some sort of thought about what you're signing. So they made actually no mistake at all because they hadn't really turned their mind to it. And there's an example that the House of Lords puts up in Sanders and Anglia, which is applicable, or analogous at least, where say you have a very busy company executive who doesn't have much time and is given a stack of documents to sign by his or her secretary, and the CEO or the executive relies on whoever's drawn up these documents and put them in front of him or her that they are all what he needs to sign, and he or she just signs them without actually taking care to figure out what those documents were. If you intend to sign what's ever put in front of you, you can't argue non est factum. Why? Well, one, you're not mistaken because you don't actually think about what the documents are. But also, you can't say it's not my deed when you just intended to sign whatever's there. That's clearly your deed. You just took the risk that it might be something that you didn't wish to sign. So they weren't misled as to what was in the document. Again, the lawyer just told them it did include a guarantee. They just weren't told exactly why that was so important. I think it's summed up nicely here at the end of 122, 123. In the present case, the purchasers trusted their solicitor. They were signing a number of documents. They believed that the documents were necessary to implement the transaction upon which they were engaged. In such a case, the law has to choose whether to allow a plea of non est factum with the potential downstream injustice to those relying on the document. Remember, the monies had been advanced to the company on the strength of this personal guarantee. If non est factum was successful, then the monies would have been advanced with none of the protection given by the personal guarantee. And again, monies advanced by a wholly innocent lender who thought that they knew what they were signing because they had solicitor's advice. Okay? So the downstream injustice of those relying on the document, or to take the view that if the signatory has a complaint, the complaint lies against the solicitor or other trusted advisor. In my judgment, it is much better in such circumstances to disallow the plea of non est factum and leave the signatory to whatever redress may be available against the solicitor than to put in jeopardy the efficacy of apparently binding document. That is one reason why the approach inherent in point 5 above is appropriate. And further down, the purchasers were no doubt entitled to trust and rely upon their solicitor. They took the risk of doing so. They have bound themselves to a personal guarantee. If they can show a breach of duty by the solicitor causative of loss, they will succeed in any proceeding against him. As a matter of policy and commercial efficacy, the purchasers should be bound and left to such rights as they have against their solicitor. So on the one hand, we could allow non est factum, allow these lenders to get out of a document that they signed, which provided a personal guarantee, and thus place all the loss on a wholly innocent lender. Or we can hold the borrowers to what they actually agreed to, thus not undermining the sanctity and security of commercial documents, contracts that have been relied upon, and focus the attention on the party who was actually at fault, if there was any fault, and that is the lawyer. In this case, the court's like, we're not going to allow non est factum because of those effects. So you can see the difference between Landseal and Bradley West. In Landseal, a finding of non est factum would not impact upon anyone but the two parties. There is no third party involved. Furthermore, the reason that it was signed was that the other party had misled the contractor as to what the contract contained. So it would not be unjust to leave the to find non est factum. It would be unjust to find non est factum in Bradley West, and it would be more appropriate, therefore, to hold the parties to their bargain, and if they lose out, for them to go after their solicitor. So when you have an argument about non est factum, first of all, it only applies, and if it's not clear, I should have made it clear earlier, it only applies to written agreements. It is a way of trying to get out of a written agreement that you've signed by saying that this is not what you actually intended. Therefore, you need to show that you had a belief as to what you were signing, and that what you actually signed was not just different, but markedly or fundamentally or radically different from what you thought you were signing. And you need to show that the reason you signed it, despite being mistaken as to what it meant, was not through any fault of your own. And if the reason you signed it was because you relied on your own trusted advisor, there are good policy reasons why non est factum will not be allowed. And finally, non est factum will not be allowed if the impact of a finding of non est factum would be to make innocent other parties lose out. So it is an escape from a objectively binding contract that you've signed, but it is a relatively narrow one, and I would argue should be kept very narrow. But according to the Contract and Commercial Law Act, section 22 3A, the doctrine of non est factum still exists and can still be argued. And that's why you need to know about it. Questions? At all? Yeah. And then we'll come to you.
Johnson case, they
Yes.
have glosses so they don't read it and therefore don't sign it. Would that be the negligent signing to it, or would that be the illness, like kind of the same as like a late man who can't read?
Right. So actually, it's a really interesting question. They didn't read in Taylor and Johnson because they didn't have their glasses with them, or they'd broken them or something. It's actually very similar to Sanders and Anglia, where the old lady in the House of Lords case didn't read it because her glasses had been broken. In that case, it was held that non est factum was not available to her. And the reason, again, was partly because, well, if you sign something when you know you need glasses to read and you go ahead and sign it anyway, it's kind of your fault. Secondly, there were third parties involved in there that the effect would be to mean that these third-party lenders would be out of pocket, and the party who misled her, because there's her ne'er-do-well nephew, I think it was, misled her, he would have actually profited if it had been non est factum. So again, the court said, no. But the question is, would temporary blindness or functional blindness apply for non est factum? Potentially, yes, but it would depend upon, really, is the reason you didn't read it your own fault? So it's not your own fault you can't read without glasses, but it's your own fault that you signed something knowing you can't read without glasses and not having them on. That's what I'd say. Sorry, question here and then up the back. Yeah.
Is it relevant for us to know the types of mistakes, like the unilateral?
Oh, yes. Hold this thought. Next week we're going to talk about unilateral, mutual, and common mistakes. Yes, they are still preserved, although the wording isn't in the Act. Yeah, up the back.
This is probably skipping ahead a bit, but what's the actual impact if it's not non-ex factum and dealt with under the CCLA?
Yes.
Because if you've got, we've got this exception, why don't you just abolish the exception and deal with all under the normal CCLA rules if the courts could just grant dissolution of the voiding of the contract under the normal rules?
Yeah.
What is the sort of exception add?
Why do they keep it? Yeah, great question. So the whole benefit of the CCLA, or the purported benefit of the CCLA, rules relating to mistake, is that they get away with this binary choice of either we enforce the contract in full or we say it's void and never existed and all obligations under it don't exist. And that the courts have great discretionary power to grant relief to do whatever they think is just. So why not include non-ex factum, or just get rid of this exception and try and bring it in under the CCLA? They could have done so, it's true. It's a very good question. I think one of the answers would be this is a doctrine that the drafters of the legislation thought was working quite well and didn't put up too many problems. Furthermore, if there was a qualifying mistake under the CCLA, which we will look at next week, that doesn't prevent you arguing non-ex factum and the CCLA as well. So you could argue both. Furthermore, there is an argument to say that actually as the CCLA has been applied, which we'll look at next week, it's relatively toothless. So actually you might, as a plaintiff, have better luck under the non-ex factum than under the CCLA. Furthermore, as a plaintiff, the benefit is you know if you're successful, the contract is void. You have no idea what the remedy is going to be under the CCLA because it's entirely discretionary. But why the drafters didn't do so, I think the answer is probably just that they thought it was fine and we'll just continue it on. And obviously they thought the same about the next doctrine we're going to look at on Wednesday, rectification, which effectively is when when equity steps in and modifies the agreement and enforces it, which we'll do that on Wednesday. So make sure you've read Dundee Farms and A. Roberts. Those are the cases we'll look at on Wednesday. Thank you, guys. It was a big slog today, but you did well. Well, you look like you did well. I can't see your subjective thoughts, but thanks, everyone.